I'm Joe Scott, a VA Accredited Attorney with Woods & Woods, a law firm that handles VA disability claims for veterans and their eligible survivors. And today I'm going to explain what steps your claim goes through with the process for a decision at the regional office level and how you can check the status of your claim. So if you want to check your claim status yourself, there are several ways to do it. You can check it online at the va.gov website. Please make sure that it does have a .gov on the website if you do choose to check online. You can typically navigate to the My VA dashboard, and around the top right corner there should be an arrow that you can select that says Track Claims, and then from there that will go into the various sets of status. You can also see if there are any open claims at that time or if they're under appellate status, which means they've been appealed for additional review and decisions. And you can also look it up on the eBenefits account, which is another way to check your status and benefits online. Additionally, you can call the VA number. That number is 1-800-827-1000. You can finally go physically to a VA regional office and speak with someone there if you would like to as well. So the amount of time it takes to make a decision is dependent upon how many steps VA has to work through in order to make a decision and if they believe additional steps are necessary. So the first step is typically noted as claim received, which frankly is what it sounds like. It shows that VA has received the claim, which is simple, but it's beneficial to know in case you have submitted a claim and there is no acknowledgement of receipt. That may indicate VA has made an error, for example, in not processing your case. Next would come the initial review stage, which is typically where the rater, or what's called the Veteran Service Representative at VA, will acknowledge the receipt of the claim and review the surface of the claim, review the type of form it's submitted on, to see if they need clarification as to what you're claiming specifically, or if they can move forward in the process. The third step, if necessary, is the gathering of evidence phase, which is where VA determines more information is needed to make a decision. They will typically either contact you, or if you've requested that VA gathers evidence pursuant to what's called their duty to assist, VA will gather evidence, but not in every situation. So it's important to remember that if there's outstanding evidence, it may be on the claimant or the representative to gather it sometimes. So the next step is review and decision part. Sometimes I just addressed the previous one of gathering evidence, but sometimes VA will sort of lump those collectively together. That's really the meat or the crux of where the decision comes from, seeing what the claim is saying, seeing what the evidence supports, seeing if VA has additional processes they need to get to make an informed decision. Preparation of notification. So if VA believes they had everything that was required, they'll prepare the actual form, they'll explain what's on the form. They should explain if it's not granted in full or denied outright, what you can do in order to appeal it successfully, what evidence is favorable to you, and then they'll gather all that information to wait to be officially sent to the individual. And then finally, complete status. That means that VA has rendered a decision and it should be on its way to the individual and their representative, if they have one, to receive it, to review it, and decide what to do from there. In my experience, VA doesn't always use exact language all the time with a standard claims process, even though the process more or less runs in a standardized manner. Different individuals may call the same thing by a different name. And if you talk to someone by calling VA, for example, they may explain it in a certain manner. If you talk to another individual, they may explain it in a separate manner. But for broad strokes purposes, those are the core elements that we've discussed. So the VA publishes the average amount of time it takes to render a decision. So far in 2023, at the time we're recording this, it's between 3 to 4 months. During the height of the pandemic, it was hovering around 5 months, I believe. So it is an average. Some claims are decided faster, some are decided slower, based upon several factors that we can influence, not necessarily control, but those are the average times. So it is possible that VA will move faster or move on to a different or separate step sooner than you might anticipate. That can happen if you've submitted all necessary evidence to make the decision. That can happen if VA was just receiving prompt receipt of the evidence that they requested, so it went frankly faster than you would expect it to. It can also get a faster decision if you qualify for what the VA says is priority processing. So some claims like terminal illness, extreme financial hardship, homelessness, claims of that nature are prioritized given their inherent circumstances. Those decisions can render faster than a standard claim that might need additional development to include a medical examination if necessary to make a decision. To help the process go faster, as simple as it sounds, making sure that all forms are filled out correctly. If possible, I typically see that VA can process things a little bit cleaner if there's mostly electronically printed information as opposed to handwriting. That may reduce the delay if the individual can't read it. That will certainly slow down the status of a claim. Filing out the forms correctly, as I've said, following the directions within the VA form, even if you believe the step is unnecessary or unneeded. Sometimes, as painful as it is, we have to follow that procedure just to get a decision, and we can then address the merits of that decision, including any new and relevant evidence if you're filing what's called a supplemental claim, which is mainly what I'm discussing here, making sure that it meets the standard VA has to see to make that supplemental claim appealable, used as an appealable decision. That would increase the speed of your claim just by making the process go as smooth as it can. If VA finds that you need to attend a medical examination, again, as unfortunate as that may be, attending the exam is necessary. VA will typically, at the minimum, delay a decision that had a medical exam scheduled that was not attended. Making sure that you thoroughly explain your medical situation, your representative can help explain what that means precisely, but to the examiner himself or herself can really help clarify what's at issue and what the VA needs to decide. Hiring an attorney can be advantageous to getting a claim decided faster, especially if the attorney is aware of how to expedite a claim, if it's eligible for what's called priority processing, making sure that all necessary evidence to the greatest extent possible is there to render the correct decision the first time, as opposed to just a generic or less than substantive appeal that may need additional development later. An attorney would know how to get the most substance out of that claim to increase the chances of it being decided properly and as fast as is possible with the VA system. So you can learn more about the VA disability process, what benefits and appeals you may be entitled to by following the links in the description to this video and on our YouTube channel as well. You can leave your questions and comments in the section below. We've most often dealt with what's called TDIU and DIC cases, and we have videos about that if you're more interested in learning about them. But if you're ready to contact an attorney about this, please feel free to contact us at Woods & Woods for your consultation, and we'd be happy to speak with you.